Hello, this is attorney Jeremy Hogan, and since I posted a video on the SEC lawsuit involving the XRP cryptocurrency, I've received a lot of comments, emails, and questions, and quickly realized there's a lot of misinformation and concern out there about the Ripple lawsuit. So what I did after work today is I compiled the most frequent questions I've been receiving, and we will go through each of them. I think if you own XRP, you might feel better afterwards, and if you don't own it, then you'll probably be bored out of your mind. So I recommend you instead watch my video reacting to Wedding Crashers. Much funner. Okay, let's get right to it now. I just have a quick disclaimer, which is do not take this as legal advice. I'm a lawyer on YouTube. Need I say more? Okay, here's the first question about the SEC versus Ripple lawsuit I'd like to discuss, and it's from Mr. Jess with the very interesting spelling. He says, here's an important conversation we would like to have. If XRP is deemed a security, fines are paid, etc., and life goes on, what happens to XRP for those of us who don't want to sell and may have XRP in a wallet, on an exchange, or in an IRA? That's a great question. I call it the doom scenario question. Now, the first thing to understand is that I don't see this happening for a couple of reasons we'll get into in a minute. But if there is a trial next year, and if Ripple loses, and if Ripple then loses its appeal, and that's a lot of ifs, then no doubt a finding that XRP is a security would be a disaster because the exchanges in America at least would be forced to stop selling XRP forever unless they register as a security exchange. And I imagine trading then after would be very limited to exchanges outside of the United States, and honestly, I don't know what that looks like. It's a little bit outside of my expertise. But the bigger picture here is that a trial verdict against Ripple would be bad, really bad for the whole crypto industry, not just XRP, but maybe not as bad as you might think. And here's why. XRP and other crypto companies have a problem in how they began their companies in their formative years, and that's evident in the SEC lawsuit. That's also how the SEC got their victory against two newer cryptocurrencies back in 2019. They were going after the ICOs, initial coin offerings. Now, whoever came up with that term, not smart, because what does ICO sound like? It sounds exactly like IPO, initial public offering, and that is exactly what companies do that sell stocks. So you've just put a humongous target on your back by calling what you're doing an ICO. It drives me crazy. But anyway, why not as bad as you may think? Because to me, it seems that the SEC's focus is on Ripple's biggest problem, which was from its early years, 2013 and 2014, where it was actively seeking to raise capital and using XRP in some ways like a security. Now, as Ripple has matured and as more coins have moved from Ripple's control out into the ether, no pun intended, and were sold to individuals and moved into the network, XRP coins became more and more like a currency as intended. So what I'm saying is that a verdict against Ripple would be a disaster for future ICOs and newer projects and coins, but maybe not necessarily for coins that are further along in their actual use scenarios, including XRP. I think that the SEC and whatever comes out of this lawsuit is going to be focused on the current and future ICOs and not coins that are further along in the process. The next comment is from Caxis26. It's good that you're young, 26. He says, or she, I read somewhere that the SEC are out of bounds making a claim outside of a 3-year period. Someone noted that they shouldn't have filed any legal claim outside of this time, which was some kind of cutoff. And I've seen a couple comments like this. They're talking about a statute of limitations. And although the SEC has received a lot of criticism for taking so long to bring this action, I want to explain how this might actually help Ripple. So the statute of limitations is actually 5 years. That's the Gabelli v. SEC Supreme Court case. And the 5 years runs from the actual violation, which here would be the sale of an unregistered security. So if my math is correct, that takes us back to December 2015. And what I want you to understand is that the statute has passed for the majority of the transactions that Ripple and the two individual defendants made. And that's a good thing. The lawsuit only brings into issue transactions that took place after December 2015. So now going on our thesis from a couple minutes ago that we just talked about, that things just get better for Ripple as time goes by on the timeline, the delay actually helps Ripple a lot. Now, it doesn't end the lawsuit because the Gabelli case says that the statute runs from the actual violation and not from the SEC's knowledge of the violation. So this isn't something that gets the lawsuit dismissed, but in that light, it can actually help Ripple. The third type of comment I'd like to comment on is actually a mix of comments, and it goes something like this. What about the opinion that Ethereum is not a security from the SEC? And what about that FinCEN lawsuit and settlement that says XRP is actually a currency or something like that? So let's start with the Ethereum issue. I own Ethereum, I don't own XRP, so I just want to let you know that. But that being said, the Ethereum opinion is not binding on the SEC. As we talked about in my first video, these cases are highly fact dependent, and all the facts are different between Ethereum and XRP. Now, with that being said, I definitely think that the Ethereum opinion can be used to help the XRP case. It's a government document and it's an opinion, and although it's hearsay, it is admissible under the Federal Rules of Evidence 803(8) exception, which is the public record exception. So it's helpful, but it's not dispositive. Now, the FinCEN lawsuit is even more interesting. If you don't know, back in 2015, the Financial Crimes Enforcement Agency, which is the agency of the federal government, went after Ripple for failing to maintain its currency, yes, currency, RXP or XRP, in a manner required by federal law. The case ended with a consent judgment or a settlement in which Ripple paid a fine and agreed to change its practices in certain ways. Does that sound familiar? So the federal government back in 2015 called XRP a currency. And now the federal government is calling XRP a security. The question is, can the feds have their cake and eat it too? Well, as far as I can tell, yes. And I could be wrong on this, but I do not believe there is any precedent or any res judicata in lawyer talk by prior lawsuits or settlements cross-agency, or where there are two separate agencies involved. In other words, I don't think the FinCEN lawsuit ends the SEC lawsuit that's currently pending. But similar to the Ethereum proclamations, I'm certain that Ripple's defense team is going to love getting that stuff into evidence. I would even think about bringing in FinCEN agents and qualify them as expert witnesses and get them to testify that in their opinion, XRP is a currency. Now that would be really juicy as a lawyer. But in any case, I think these prior opinions and actions are persuasive and very useful, but not dispositive. And finally, my favorite question from my last video from JJ Jones. Has this guy been drinking? No, I usually do these videos at the end of a very long workday, and this is just what being a lawyer does to you. Anyway, thank you for watching. Hope to see you next time. Have a great day.